Namaste, friends. Welcome to our Sunday edition of Words of Wisdom Gyan Ganga on our Virat Hindustan Sangam social media channels. Today, we have an important discussion with Dr. Subramaniam Swami and Advocate Satya Sabarwal. Both of them are petitioners and co-petitioners in two PILs which are pending now under consideration by the Supreme Court of India. So the next 1 hour, we will be discussing these two PILs filed by Dr. Swami and Satya Sabarwal in the Supreme Court of India. The first PIL is regarding deleting the words secularism and socialism from the preamble of the Constitution, which was introduced during the days of the emergency by Srimati Indira Gandhi and which was not there as given by the founding fathers of the Constitution in 1949-50, effectively from 26 January 1950. So Dr. Swami has filed this petition for the removal of these words, socialism and secularism, from the preamble. This other petition, PIL, which is pending is that which now Supreme Court has issued notice to the government of India and has asked them to reply within 2 weeks, is the challenge to the Places of Worship Act 1991, where Dr. Swami has pressed for liberating the Gyanvapi Kashi Vishwanath Mandir and the Krishna Janmabhoomi Mathura temple from the ambit of the said act, as that original act had excluded Ram Mandir Ayodhya temple. So the next 1 hour, we will be discussing the importance of these two PILs and its implications. I have to thank our technical team led by Ashish Shetty, Ishwar Iyer, Tejas Navalgul, Ajesh Nair, Rakesh Gadgi, Swaminathan and Vishal Mehta for their regular inputs for putting this program together. I also have to thank our viewers across the globe for their patronage, and more than 120 countries our program is watched on every Sunday. I have to thank my co-host Professor Arvind Chaturvedi from Delhi and Sri Ramesh Swami for co-hosting this program every Sunday. We thank you all, and it is over to Dr. Subramaniam Swami and Advocate Satya Sabarwal, and I thank both of them so that our viewers can know the legal implications of this 2PIL and what it means to India. Over to Dr. Swami. Thank you.
Thank you, Jagdish. One of the greatest anomalies since 1947 has been that of all the religious groups we have in India, the Hindu, which is the Hindu group, which is about 82%, including our associate religions recognized as part of Hinduism by the Constitution of India. And that is about 82%, as I said. They are the only religious group in India who are subject to government control of their religious institutions. So the temples, for example, come under government control. What is the legal limits to which government can control a temple has been decided in 2014 when the Sabhanayaka judgment was given in my petition, when Karunanidhi's government had taken over the Nataraj temple, which is also known as the Sabhanayaka Nataraj temple in the town of Chinnabram, and took it as part of his government for administering it. And then I had gone to court at the request of Swami Dayanand Saraswati and got success. We got a judgment which has laid down certain fundamental rules which all governments have to obey, but they are not obeying today. Is there any Muslim religious institution which the government has taken over? No. Is there any Christian? Now, see, the Christian churches were given land for 99 years, and that has elapsed 10 years ago. And they are living on land without a formal right to it. But no one has any guts to send them a notice. But for temples, there are probably 4 lakh temples which have been taken over by different state governments. Center can also take over, but the central has not taken it over. But this seems to be a kind of a malady, because even BJP government in Uttarakhand took over all the temples, including Badrinath, Kedarnath, so on. So what we are trying to do, both Satya and myself, and also Vishesh Kanodia, who couldn't make it to this program, otherwise we would have had him on this program also, another very bright youngster like Satya. So what we are trying to do is create a basis by which the temples of India are able to be religiously free, even if there are some limitations on the financial, which has got nothing to do with religion, financial aspects of maintaining the temple. So it just turned out that during the before the Babri Masjid demolition took place, Sahabuddin Sayyid Shahabuddin, a friend of mine, General Secretary of Janata Party, when I was also General Secretary, very good friend of mine, had vast differences, but we were able to discuss amongst ourselves. He finally agreed with me that yes, Ram Temple is so foregone now that it is going to be built, and so it's quite clear. But other than that, I will not agree to any other masjids to be removed. Now, let me add, before Satya gets into the nitty-gritty of our 2 cases, that masjid, according to Islam, I'm not talking about me, and the Supreme Court's constitutional bench of 1994, Ismail Faruqi versus the Union of India, that judgment says that masjid is not an essential part of Islamic religion. It can be broken, it can be shifted, and so on. In Saudi Arabia, they're doing it. If you go and see Google and put Turkey, Turkey is either Erdogan. He has demolished masjids and masjids in Turkey because he wants to build a highway. And he says so. I will build a masjid somewhere else. Masjid is only a place to read namaz and nothing more. There's no, Allah is not there. It's you're reading namaz to Allah, of course, but the institute, the building is not a religious place, like a temple. So, but in our country, we have no rules, no regulations on the maintenance of temples and churches. Churches, all kinds of wrong things are happening in several churches, like they happen in temples also and in masjids also. But in the case of the temples, the government immediately moves in. It's almost as if they want to control it. In places like Tamil Nadu, the DMK, which doesn't believe in religion, this DMK is taken over the maximum number of temples, and they're looting its money, and so on and so forth. So we decided that we will set some further landmarks by which temples cannot be taken over easily by the government. Government has the power if the financial, non-religious part of the temple is not in accordance with the laws of the country. Then the government can come in only for that purpose, rectify it, and then leave. That's the order and decision of the Sabanagar temple case of 2014, Subramaniam Swamy versus the state of Tamil Nadu, which is a landmark, which has to be now implemented all over the country. But it's not being implemented because there's nobody to take it forward. So, in that context, we are now in a position where we are going to be discussing the temple takeover or the block that is being put in. The first case we are discussing is that passed by the Narasimha Rao government, that no religious institution after 15th August 1947, when they were standing there, will ever be touched, with the sole exception of the Ram Janmabhoomi. He made the law made an exception. Places of Worship Act 1991 has a provision that Ram Janmabhoomi, Babri Masjid situation, there can be a change, but except that, no other religious institutions, masjid, church, temple will be can be demolished. We have challenged that, not so much as to say no, you can't do that. What we are saying is, yes, you have made an exception, and Satya will now give you the details about it. You made an exception for Ram Mandir, but you have to make two more exceptions. One is the Kashi Vishwanath Gyanvyapi Shiva temple, which is Jyotirling was put there by Shiva himself, and the other is the Krishna Janmabhoomi in Mathura. Why? Because these three temples, Ram Mandir, the Ram Janmabhoomi Mandir, then Krishna Janmabhoomi Mandir, and Kashi Vishwanath, these three cannot be replicated anywhere else, because these are all God ordained places. And so three should be exempted, or the act should be scrapped. That is our prayer. And so at that point, I'll stop. And as far as this is concerned, and then hand it over to Satya soon, after telling you the other petition of ours, which is coming in for hearing on the 23rd of this month, is that the preamble of the Indian Constitution, Indira Gandhi, in the emergency when all of us were either in jail or people like me in abroad or underground and so on, that kind of thing, when we were not in a position to challenge her or vote against her or put our point of view, she got a law passed saying that the preamble of the Constitution. See, the Constitution has two parts: preamble and the various sections of the Constitution and the articles of the Constitution. So, in the preamble is the direction given, and you can. It was decided in 26 November 1949 by a vote of the Constituent Assembly, and it cannot be altered in any way. So Indira Gandhi violated that and put in socialism and secularism. We are not against socialism or secularism, but it cannot be put in the preamble, because whatever is put has been put and it's done and final. So people are trying to say we are anti-secular, we are anti-socialist, and so on. That's not the consideration. Of course, I think socialism has failed all over the world. It's a bloody disgrace for any party to talk about socialism today. Secondly, secularism is so vague, we don't know what it means and so on. All that I can say when this debate is not on that issue. The issue is that in the preamble, nothing new can be added or subtracted. And that's exactly the opposite of what Gandhi has done. So on that two bases, what have we done? where is the matter standing, how far it will go, and do we think we'll be successful? I'd like to hear Satya, who I must say has done all the drafting work. He filed the petition, he did the research, and I've just climbed on it and sat on it and enjoying it because I'm also very proud that he was an intern with me earlier when he was a student, and now he's become a flourishing advocate, and he's already been chosen as the standing counsel for the Tirupati Mandir. And so, if you ever want to visit Tirupati, get after Satya and get you a pass. Over to you, Satya.
So first of all, thank you so much, sir. It is indeed a pleasure and honor to work under your guidance. But it is not that I have worked; it is just your blueprint. I have just typed it and presented to you. But so today we are discussing two cases and two petitions that we have filed it in the Supreme Court under Article 32. One is discussing the unconstitutionality of the Act, the Places of Worship Act of 1991, and the other is the inclusion of two words, socialist and secular, in the preamble via the 42nd Amendment in 1976. First, I'll cover what is there, what is our ground, what is behind the Act, the Places of Worship Act 1991, so that it reaches out to people. They can understand that here we are not to have any discomfort between two denominations, but this is actually an act which violates the basic structure of the Constitution, and how I'll explain you. See, the Act of 1990, the Places of Worship Act of 1991 has a very, the pith and substance of the Act. If we see, what is the basis of the Act? That is Section 4 of the Act. Now, Section 4 of the Act deals that any suit, any proceeding which are pending with respect to conversion of one place of worship to another place of worship shall be obeyed. And as it existed on 15th of August 1947, it will freeze. See, they have barred the jurisdiction of the honorable courts. They have barred the judicial review of the honorable courts. And this is where our Article 32, read with 25, 26 are violated. Article 32 of the Constitution, which is part of the basic structure of the Constitution. In fact, I remember Dr. Bhimrao Ambedkar's words that this is heart and soul of the Constitution, which provides judicial review to the people, which provides enforcement of fundamental rights for the citizens. That is Article 32. You can't bar the jurisdiction of the honorable courts. You can't say a certain proceeding can't be filed, that a certain writ can't be filed in the Constitutional Court. Any act, any statute, it can't do that. And there are numerous cases where certain inclusions have been made in the acts, in statutory acts, and been struck down by the court, which I'll deal later. But first, what is Section 4? It has abated all the proceedings, and the act itself is unconstitutional. Secondly, if we leave Section 4 for a second, if we, for example, for any act, Section 2 defines what the certain phrases used in the act is. There they have used a phrase, defined place of worship, and there they have equated temple and mosque all together. To my understanding, this has also diluted to that extent that in 1991 this act was enforced, but in 1994 Ismail Faruqi judgment came in, which explained the religious character of a certain place of worship, that is mosque. It has explained the religious character of Ram Janmabhoomi or temples generally to in the judgment, and it has held in paragraph 52 that mosque is not an essential part of Islam. Therefore, to equate the same religious character of two places of worship on the same definition is also ultra vires. Secondly, in the petition itself, we have asked to read down Section 3, Section 4 of the Act, and declare it unconstitutional, void ab initio. Now, what is void ab initio? That from the very beginning, this act is ultra vires. And as it completely destroys the basic structure, you can't take the judicial review out of the courts. You can't bar proceedings. As my right, I have the right to file any proceedings. You can't take away my right. My right to sue is always there. You can't take away. There are numerous judgments of the trial court as well as the Supreme Court, which has dealt with this question in great detail. So therefore, my point is that taking away the basic structure why this act itself is violating the basic structure of the Constitution. Secondly, it is also very surprising for us to see that 1991 this act was passed, and on 6th December 1992 Ram Janmabhoomi and Babri Masjid incident took place. And it is very surprising to see there is no mention of the Places of Worship Act violation in Ram Janmabhoomi FIRs, which was registered, later quashed by the Supreme Court. So the particular act is very diluted. Thirdly, what we have to see is that what is the intent of the legislature when they make this law? What is the pith and substance of the judgment? What is this act actually trying to do? This act, in fact, if we see, is an act of culpable legislation, I will call that. If you can't do something directly, you do something you can't even do that indirectly. You see the pith and substance of the act. What is the act doing here? By barring the jurisdiction of the honorable courts, by barring the judicial review, you are in fact freezing. You're freezing a certain place of worship that no other proceeding can, with respect to conversion of one place of worship to another, can take place. This is violative of my Article 25 of the Constitution. I have a right to pray in a certain place of worship which is significant to my religion, which is extremely significant in its character. I will say that where Jyotirlinga is there are only 12 of them. So it has a certain stature, it has a certain significance. I have the right to go there and pray. Similarly, where Ram is born, it has a certain significance. Where Krishna is born, it has a certain significance. So therefore, this particular aspect is very well recognized in the Act. If we see, there's an exception to it. If you read Section 5, it has recognized that there are certain disputes which are exempted. All the petitioners here are saying that you extend that to two more places of worship which are significant. I'm not saying you open a Pandora's box of 40,000 more temples which were destroyed. Certainly that will make a certain chaos, but certain riders can be put by the court that, if this is of a certain significance, then you have a right to approach court, and the court will definitely get into the legality of the issue and decide on merit. Whether my faith tells me that Ram was born, my faith tells me that Krishna was born, it has to get into that. If my faith tells me, and the precise faith is also which is enshrined in the preamble, I will read from the preamble that it secures liberty of thought, expression, belief, faith, and worship. The preamble itself says it has to secure my belief, my faith, and my right to worship, and very much which is also enshrined in the fundamental rights, Article 25, 26, and so on. There's rights which are my religious rights, which have to be protected by the state. They have to. Your court has to strike down if the state is not overturning it. Secondly, which I forgot to tell you also, that in the Ram Janmabhoomi, there is no mention of the Places of Worship Act, which itself dilutes it. And there is also no need of having a Place of Worship Act, because there is already a provision in the Indian Penal Code which protects destroying of a certain place of worship. If we read Section 295 of the IPC, it has provision where a person destroys a certain place of worship, and there are riders to it also. They destroys a certain place of worship, he will be penalized. There's no need to have this act. A similar case was also adjudicated by the Supreme Court, where I remember it was Dalbir Singh versus State of Punjab, or Punjab versus Dalbir Singh, where they had held that there's already a certain provision, 302 IPC. Therefore, you don't need, they had amended the Arms Act section 27, where you don't need a certain provision which overlaps with a certain section which is already part of the penal code. Similarly, here there's already section 295. You don't need Places of Worship Act. So that is the crux of the matter, that you can't destroy the judicial review. You can't destroy the powers of the court. There's a separation of powers. No law can come in which destroys the basic principles on which the constitution is standing, the basic structure of the constitution. It is heart and soul of the constitution in Dr. Bhimrao Ambedkar's words. So it's an act of caliber legislation, and I'm confident about my arguments adopted by Dr. Swami. It will be read down, and it will be read down with these riders that certainly court also has to see. They can't get into other they can't get into a Pandora's box of allowing you to go into more temples, but certainly they will get into certain riders be set. Now, the second petition that we have filed is to take two words from the preamble. Now, what the preamble originally was, that the Constituent Assembly on 26th November 1949 had said, "We, the people of India, have solemnly resolved to constitute into sovereign democratic republic." But this inclusion violates the 42nd Amendment, which is historically false and involves a patent contradiction. Today, the preamble that we read is that the Constituent Assembly on 26 November 1949 had resolved to constitute India into sovereign, socialist, secular republic, democratic republic, which is false. And moreover, it's the Constituent Assembly which is giving the preamble. If the amendment was done, it was done by the Parliament, not by the Constituent Assembly. So there is something which is completely patent contradiction happening, a historical false inclusion in the preamble which is there. Secondly, which is also very shocking, that we have added two words, socialist, secular. I am not going into the integrity that what is the meaning of these two words. Certainly, they're not defined. But the preamble itself has defined, the judgments of the Supreme Court has defined that the words in the preamble cannot be vague. They are well-defined words. But socialist, secular, which are not certainly defined anywhere, is something which was concern. Secondly, Schedule 7 of the Constitution, List 3 of the concurrent list, in item number 28, deals that that state will make laws with respect to religious institutions and charitable institutions and religion institutions. Well, if that is certainly in the concurrent list, then what is the need of putting secularism in the preamble? Secularism, in the terms of, if you go into the Oxford Dictionary of what is the meaning of secularism, is that you separate church and you separate people. You separate these two things. State and church, you separate these two things. In that context also, it is violative. Thirdly, there was this judgment which is passed in 1973. Citation is 1973 4 SEC 225, which is Keshananda Bharati, which is of the largest bench in the Supreme Court in the history of this country. 13-judge bench was set up, and the Keshananda Bharati had held that the contents of the preamble are part of the basic structure. Whatever there is in the preamble is making part of the essential features of the Constitution, and that was frozen by the court in 1973. Well, this particular amendment came in 1976, which again is violative of Keshananda Bharati, and it should be struck down by the Supreme Court. Thirdly, there's also one more act where, for example, any political party, if it has to be registered, it has to go through Representation of the People's Act 1951. Well, this act in section 29A, 29A5 deals that you have to show allegiance when you have an affidavit and an application, you have to show that you have allegiance to socialist and secularism. Well, uh, this is also why this particular amendment should be strike down, because again, this is very much against the basic features what the constitution itself stands on. And this was the reason why Dr. Bhimrao Ambedkar on 15/11/1948 in the Constituent Assembly debates had dealt that, and I'll read from the debates itself. What should be the policy? This is Dr. Bhimrao Ambedkar saying. What should be the policy? What should be the policy of the state? How the society should be organized in its social and economic side are matters which must be decided by the people themselves according to time and circumstances. It can't be laid down in the constitution itself, because that is destroying the democracy altogether. If you state in constitution that a social organization of state shall take a particular form, you are in judgment taking away the liberty of the people, and you have to give it to the people to decide. So again,
Satya, that's a very important point that you mentioned, what Dr. Ambedkar said. Can you paraphrase that in Hindi also? So a lot of requests are coming. That
yes,
just you said about what Ambedkar said. It's so crucial.
yes,
That where he said that it's up to them.
Yeah, I'll repeat it again. This is
in
volume
Hindi.
In Hindi. Just paraphrase it in Hindi.
Okay. So इसमें जो डॉक्टर भीमराव अम्बेडकर प्रस्तुत करना चाह रहे हैं, कहना चाह रहे हैं, वो ये है कि आप जो ये सोशलिज्म और सेक्युलरिज्म दो शब्द हैं, ये एक आइडियोलॉजी है, ये एक पॉलिटिकल स्टेटमेंट्स हैं, ये एक पॉलिसी का, एक स्टेट का पॉलिसी है जो आपको लोगों को पे ही छोड़ देना चाहिए. आपको अपने ऊपर या तो एक प्रियम्बल के ऊपर नहीं लगाना चाहिए, आपको लोगों पे छोड़ देना चाहिए, गवर्नमेंट पे छोड़ देना चाहिए. उस टाइम पे वो पॉलिसी होगी तो वो उसको एग्जीक्यूट करेंगे, बट उसको प्रियम्बल में डालना उनको सही नहीं लगा. इसीलिए उन्होंने कॉन्स्टिट्यूशन असेंबली में बोला कि ये चीज गलत है, और हम क्या 70 साल बाद 80 साल बाद क्या होगा वो हम उन लोगों पे छोड़ना चाहते हैं. आज अगर हम इसको प्रियम्बल में डाल दें तो वो गलत होगा. वो ऐसा होगा कि हम वो जो जनरेशन आएगी आगे, जो लोग आगे आएंगे, आप उन पे कोई चीज थोप रहे हैं, ये ऐसा कहा जाएगा अगर हम इसको प्रियम्बल के अंदर डालते हैं. तो इसीलिए 3 नहीं, 2 नहीं, 1 नहीं, 2 नहीं, 3 बारी इस चीज को कॉन्स्टिट्यूशन असेंबली से रिजेक्ट करा गया था. तरीके काफी डिफरेंट तरीके से इस चीज को लाया जा रहा था कि क्या हम इसको UISR ले आए, USSR की तरह, या किस तरीके से इसको लाने की कोशिश करें. तो 3 बार ये चीज रिजेक्ट करी गई थी कॉन्स्टिट्यूशन असेंबली की, और यही रीजन था कि वो चीज आज भी प्रियम्बल में नहीं होनी चाहिए. और जिस तरीके से वो प्रियम्बल में आई वो भी गलत है, अनकॉन्स्टिट्यूशनल है, वॉइड अब इनिशियो है, और उस चीज को कोर्ट जरूर स्ट्राइक डाउन करे. ओवर टू डॉक्टर स्वामी.
I will ask you some questions now. First of all, according to my knowledge, which many people have gone into this question and listed the number of temples that were demolished, and they came to the conclusion that the number would be about 40,000. Now, I ask you a question. Why is it that we can't build 40,000 new temples in another place? After all, we go to the temple to pray. Whether it is in this place or this place, what does it matter? Why you are asking that Ram temple must be where Babri Masjid is? Krishna temple is where Krishna, masjid, whatever it's called, is. And same thing with the Kashi Vishwanath temple. What is the difficulty? All right, at that time the Mughals were ruling and they imposed this on us. Now we're in power. Well, we'll rebuild the temple. Why must we demolish a temple or remove that temple? Why we should demolish a masjid and remove it and send it away I think of course, by the way, let me also add, in Goa, many of the temples were destroyed by building churches. So it's not only the Islamic forces which did it. So we in our petition are making a distinction.
Yes.
3 को छोड़ दो, फिर बाकी सब ठीक, हम दूसरे जगह में बना लेंगे। अब उसको नहीं मानोगे तो फिर हम कहते हैं पूरा ही हटा दो। वह क्यों 3? तो ये जो विभाजन किए हमने, व्हाट इज योर आर्ग्यूमेंट फॉर दैट?
Sir, the intelligible differentia that we are taking here, that we are not getting into the 40,000 temples, या हम अगर वो 40,000 टेम्पल में ना जाएं और ये जाएं कि ये 3 टेम्पल जो हमारे बहुत सिग्निफिकेंट हैं, इन पे अगर हम ज्यादा फोकस करें, उसका ये कारण है कि यहाँ पे हमारा एक पर्टिकुलर सिग्निफिकेंस है। हम ये बोलते हैं कि राम जन्मभूमि, राम लला वहां पे पैदा हुए, वो राम जन्मभूमि है। अब राम लला और कहीं पैदा नहीं हुए, वहां पर ही पैदा हुए, वो उसका सिग्निफिकेंस है। Similarly, if we talk about Mathura, we see that Krishna was born there. Our faith tells Krishna was born there. There are many evidence which says Krishna was born there. It has a particular significance. उसका वहां पे एक significance, एक तथ्य है कि वो वहां पे पैदा हुए, इसीलिए वो हमारे लिए इम्पोर्टेंट है। इसीलिए हम चाहते हैं कि कृष्णा जन्मभूमि, राम जन्मभूमि और काशी विश्वनाथ, जो 12 ज्योतिर्लिंगा में से एक है, वो वहां पे है, और वो 12 ज्योतिर्लिंगा ही वहां पे है। अब ज्योतिर्लिंगा और कहीं नहीं हो सकता। वहां पे शिव जी ने खुद ज्योतिर्लिंगा लगाए, तो वो वहां पर ही है। अब मैं बोलूं कि यहाँ पे ज्योतिर्लिंगा नहीं है, मैं वहां कर लेता हूँ, वो that will go against Article 25 of the Constitution. That will go against my faith, and that is which is extremely important for people practicing religion, that we want our faith to be protected, and that is on the basis of which the preamble also stands. It secures my faith, it secures the liberty of my right to worship, it secures it. And therefore I say this particular temple, which is which has a certain significance, is important. For example, for Muslims, their Makkah Medina is important. That can't be destroyed. They have that is their fundamental right. But other mosque, which has been held by the Supreme Court itself, that it is not a part of the that temple, that mosque is not an integral part of the Islamic religion and can be shifted from one place to another. It's been held by the Supreme Court, which is also upheld in 2018 by Justice Bhushan's judgment. Therefore, I say that these particular temples are integral to us. It is important that we secure our faith liberty connected to these temples, which is enshrined in the preamble.
What to summarize what you said, and then I'll ask one more question, then I'll hand it over to my other colleagues to ask you questions.
Sir.
What you are saying as far as the first places of worship act which we are challenging is that there are 2 more temples which have to be built where a masjid stands today.
Yes.
Out of the 40,000 temples which are destroyed, 3 are allowed to be reconstructed. The remaining need not be by removing the masjid and building a temple in the same place, but it can be built another place, because it was not a place where anything special happened. They are just going there to pray to God, that's all. Whereas here we are going to pray to the birthplace or the Jyotirling place which the gods have imposed. So I understand that this is what you are saying, and it makes perfect sense. And I think the Muslim community should immediately accept it, that out of the 40,000 temples that were forcibly, they were not by democratic vote decided, the Mughals decided to demolish it. They used force, they killed people, So we want to forget that chapter. So we say, leave these three. The remaining, we are not going to insist. You let your mosque be there. So that is what we are saying. And if the three also are opposed by the Muslims, then we have no alternative but to go ahead with our petition and say this act itself should be scrapped.
Absolutely.
So if you have made an exception for Ram, you must make two more exceptions. After that, no more exceptions, and the matter is closed. That, or if you don't even agree to that, if the Muslim community comes as a counter in the court and says, no, we can't even accept these two also. We accepted one, but now we will not accept the other two. Then, of course, I will argue that the act, our petition should be accepted, and we should be free to restore any temples that we want by majority vote or whatever you want to call it. This is point number one. Point number two is, you are saying that you have nothing against socialism and secularism, but you cannot introduce it in the preamble because this was raised. Ambedkar rejected it, then it was put to vote, and they lost the vote also. And now you suddenly come and say that I'm going to put it in the preamble, which cannot be amended at all. It is part of the basic structure, as you said. So ये मूलभूत जो ढांचा है उसको छेड़ नहीं सकते हो. उसमें ये जो this preamble is there, जो शुरू में जो अपनी लक्ष्य को या अपने सिद्धांत को प्रस्तुत करती है, उसको हम छेड़ नहीं सकते. और आप छेड़ोगे तो फिर तो कहीं भी रुकने के लिए सवाल नहीं होगी, और हमारी सारी जो संविधान है उसकी सारी अर्थ खत्म हो जाएगी. यही आप कहना था, मैं ऐसा समझता हूँ. अब any more questions, any other questions the others want to ask?
Yes, sir. There are Jagdish ji, you unmute yourself. You ask a question. I have lot of viewer questions also. You finish your question, then I'll go to the viewer question.
No, there are some viewer questions, and this is a joint question to Dr. Swami on one angle, and also Satya on the legal angle, and Dr. Swami on the political angle. Some of the viewers want to know that in both these petition, because it's a writ petition, I understand, the government is the party, the government of India, the Union of India is the respondent. So would the Union of India not have to take a stand and file an affidavit? So I want to understand from Satya, the court procedure, how is this procedure? How does the government respond to these petitions of Dr. Swami and yours? And I asked the same question to Dr. Swami. How you think politically the government of India will field this affidavit or file this affidavit? First, perhaps Satya can enlighten us what is the respondents and what they will have to do, and then Dr. Swami can take the political angle.
I will certainly say, sir, this is a very well-framed question on the legal aspect and on the political aspect. But certainly, sir, our notice was issued on 27th June 2021 in the Places of Worship Act. And duly, we had filed our process fees, and it was served on the union, our two respondents, which is Ministry of Law, and another union is a party, where we have served it to them within limitation. Subsequently, there were some other petitions also. And on the last date of hearing, I remember Chief Justice of India, he had raised this question as if any affidavit is filed or if union is filing any affidavit. And 2 weeks time to file the affidavit was given to union, that please you furnish your stand and please clarify, file an affidavit to the Dr. Swami's petition and onto other petitions also. So that is the legality of it. That is the law. You're given due time to file the affidavit, any petition for that matter. Maybe you can file a affidavit saying we are supporting the petition. There's no ground which we are against. We are supporting the petitioner. It's non-contested. It is passed. Court passes it. But in this case, there are other interventions also in places of worship which are filed, and notice has been issued on that. The court can also file. Union will also file affidavits to all the interventions. Maybe they can also file a common affidavit. So that is on the places of worship. On the other petition, notice is still to be issued, but as Dr. Swami had filed it, it was widely reported in the news. There's one more petition which is filed, which is uh, uh, which is which talks about that the prayer of the petitioners in social and secular should not be accepted by the court, and to that court will hear on 23rd of this month and will pass appropriate orders. But still, notice is yet to be issued. But on the places of worship, notice has been issued, and a union has to file in 2 weeks.
Well, let me say, you asked what is going to be the political authorities' view on our petition. Of course, the Union of India, as it's called, that is the government of Narendra Modi, is represented in court by the additional solicitor, the Solicitor General, Mr. Tushar Mehta, who was present in the court. He has taken notice. Now he has to file a reply. I am a little puzzled by two things. In the Ram Setu matter, the decision to adopt the Setu Samudram ship channel project was by the Vajpayee government, which meant cutting the Ram Setu and allowing the water from Pak Strait to come into the Gulf of Mannar, and so that ships can go through and between India and Sri Lanka. There was an uproar in the country, and no one from the, I wasn't in BJP that time, I was the president of the Janata Party. No one from the BJP took a stand, because they all had voted for it to break Ram Setu, so to build the Setu Samudram project to please their ally DMK. DMK was their ally, so they wanted to please it. Without DMK, a government would have fallen. Now, finally, Ashok Singhal of the Hindu Parishad came to my house and he said, "हाथ जोड़कर कहता हूँ कि आप इसको बचाओ." So that is how I got into Ram Setu, and I fought it in the courts, won it, and the Setu Samudram project was cancelled. And then by the time our government also came to power, and the shipping minister became Nitin Gadkari, and he made an announcement, Ram Setu will not be touched. But now the second thing which I have a petition on from that time, and now it's come up, is in future nobody should destroy this Ram Setu, and Ram Setu shouldn't be allowed to be also wasted away. So it should be looked after. So make it into a national heritage monument. And we have many national heritage monuments. Even where Jawaharlal Nehru met Edwina Mountbatten in Simla, that building has been now made into a national heritage monument. I don't know what kind of heritage that is, but anyway, the previous government did it. So there's nothing wrong with declaring it as a national heritage monument. It is a national heritage monument. But the present government, Mr. Modi's government, is refusing to take a stand in the Supreme Court, nor tell them what our stand is. They are not replying to my petition. It's just getting by adjournment. Adjournment is getting a thing. So the question, when you ask politically, today, this act, government should have taken this as a great opportunity, said, yes, we fully support Dr. Swami. The matter would have ended there. And the court would have immediately passed the thing that, or they could have said, yeah, okay, these two also should be allowed. Krishna Janmabhoomi and Kashi Vishwanath, and but otherwise the remaining will remain as same as per the act or scrap the act, whichever. But the government of India can make our life easy in court by simply saying government supports the idea that the Kashi Vishwanath, from where the area from which Modi has got elected this time twice, and Kashi Vishwanath and Mathura, Krishna Janmabhoomi, they will not be, they will not remain masjids. They will become what they were originally, but all others, 40,000 temples that were destroyed, the remaining will remain. We will be, if we want to rebuild it, we'll build in some other place because there's no sanctity about the place. So the place can be anywhere else as long as the murti is the same. So this is how the government should go. But for some reason, we saw in Uttarakhand also the BJP government had nationalized all the temples. And then I went to court, and then there was big halla gulla on the ground, and thereafter the government withdrew it. Otherwise, they would have lost the elections. So this is the political situation. I'm very disappointed with the foot dragging attitude and the obstructionist attitude of the present government.
Dr. Swami, now we'll take a couple of questions from the viewers, actually.
Yes.
We have about another 10 minutes to go. When Indira Gandhi brought in this amendment to the preamble, right, it happened during an emergency.
Yeah.
How do we prevent another of such an incident happening? Because once let's say you will win the argument in court, is there a way to prevent this by doing another 352 and saying they're just bringing it on, or is that we have to deal with it as it comes?
Well, I mean, if you're in the minority, the majority can always bring it again.
Okay.
So I'll tell the people of India that if you want to protect the country's culture, please make sure that the party you vote is not a party which hates Hinduism.
The second one, can the government just go issue like an ordinance or something to say declare Mathura and Kashi and end the matter, or is that possible?
Absolutely. All they have to say is that the government is taking over both these places under there are two, three sections, I think, in the constitutions.
300A.
Yeah, 300A. That's right. The government can take it over and declare that we are rebuilding what it was originally. And I'm saying that if you can think of something for other religions where the Hindus or the Buddhists or the Jains have demolished or the Sikhs have demolished, you please tell us. But as far as these, particularly these two temples, I think government should be coming forward, not have persons like me go to the court and take the time of the court to do what is in our manifesto.
And just adding on to that, government can have two things. One, they can take over directly the temple. Second, they can also amend the places of worship and say we are adding two more exceptions to it, and then leave the ball in the court's court that you educate the matter, go on merits and decide. These two things can happen.
Yeah.
Satya, there was one question I just popped up. Is the Waqf in the Waqf Act also a part of this religious act? Is it some way connected or not connected?
Sorry, sir, what is the question?
Waqf board.
Waqf board.
Yeah.
Is that also a part of religion, religious or
Places of Worship Act? Is it related?
Or can it be also interfered with government?
Yes, actually, that is also something which is important. This was also raised by one of the petitioners, though they have there are multiple interventions that were filed in the court. So this was raised by one of the interveners, that the Places of Worship Act, apart from violating the Constitution, also violates the Waqf Act, because Waqf Act has a certain procedure to which it regulates the mosques, that say, if it says that, and which says that if that a certain mosque can't be in a certain place. Similarly, the place of worship has, in effect, they freeze the dates. Therefore, it is also violative of the Waqf Act. So that was also argued, but I haven't read that argument. There are multiple interventions. They'll all be served to us. Once it is served, I'll be happy to assist in a larger point. What particular argument was raised? I'm just telling you in court that this had happened.
I'll add one thing. There was a time when we regarded property as a fundamental right, but now it has been scrapped. So if there's a Waqf board which is sitting on a temple which is holy for us, Waqf board doesn't have any rights. There was a question which was being scrolled. That's why I'm answering it. We can ask the Waqf board to go to another place and maybe give them some compensation, but they don't have any such rights where somebody's fundamental rights are involved.
Swami, you had a question. Go ahead.
Dr. Swami, if you can throw some light on the parliament discussions which has happened on the Places of Worship Act, and you moved an amendment that was 12th September 1991. So if you can enlighten us on those discussions, it will be helpful for us.
I also didn't vote. I walked out in disgust.
Yes.
So even though I was an extremely good friend of Narasimha Rao, and I told him that this is all very wrong. I cannot accept it. And I was not in BJP. I was president of the Janata Party at that time. I had no responsibility to carry the Hindutva movement forward, although I felt very strongly about it as a Hindu. And as far as my amendments are concerned, I was trying to moderate its thing, saying that other holy places should also be included for the exemption.
And you also said if it is proven scientifically, and the same argument which you advanced today, that if it is proven scientifically that you can demolish the masjid and move on with the construction of the temples.
Yeah. See, let me tell you one thing. Except for 3 places, like we have 3 places, Muslims also have 3 places: Al-Aqsa, Medina, Makkah. 3 places, they are holy. God has been there. So you can't touch those. But otherwise, mosques can be. This is there in the constituent. That famous Ismail Farooqi versus the Union of India case. It was a constitutional bench which said masjid is not an essential part of Islam. It can be shifted. It can be demolished. It's there in black and white. Constitutional bench of the Supreme Court has said this. So anyone says, no, the masjid, I built it, now you can't unbuild it. Sorry. Kashi Vishwanath, Mathura, they can be shifted. Government can acquire it under Article 300 and then move it out. If you want bloodshed, that's another matter. But I personally think that the Muslim community should know that masjids are shifted. In Babri Masjid has been shifted. Now it's a much better looking masjid they have got, which is being built in Faizabad, which is now I think called Ayodhya district. So therefore, I think, to be frank, the Hindus have been much too flexible. After all, we did fight for the fight against. We fought the Mughals. We defeated them. In the year 1796, the Marathas defeated. They finally broke the back of the of the Mughals. Today, can anyone tell me who's the descendant of Aurangzeb? You can't. I can tell you who's the descendant of Shivaji. I can tell you who the descendants of Rani Jhansi. But you can't name one descendant of Aurangzeb. So that is the extent to which they were wiped out by the Marathas. And then, of course, the British came and were already very weakened, and we have fought, and we are tired, and the British were able to take over. But ultimately, the British also had to leave. So this country has always been hospitable. We have been extremely hospitable to the Zoroastrians, the Parsis as they are called, the Jews. The Jews have themselves declared in their parliament, thank you, India, the only country where the Jews could live as human beings. You know, that is the tradition. And I would like certainly the Christians and the Muslims to be a little more flexible in dealing with the atrocities of the past against the Hindus.
One last question, Dr. Swami. This is kind of a
No,
bad
I have
question.
I have 2-3
No,
questions.
Arvindji, if you don't mind, after this you can take over and surmise in Hindi and ask questions. Dr. Swami, the Waqf board is Waqf in generally is not mentioned anywhere in the constitution. How come they have enormous powers over property when the Hindus don't have?
Well,
Satya, you have an answer to that?
it's called appeasement. It's a
Appeasement.
disease that Indian politicians have.
Arvindji, go ahead.
Okay, before I summarize the program, Dr. Swami, I have some observations which I think I would like
Hindi,
to-
please, Hindi में please.
Hindi
में बोलिए please.
डॉक्टर स्वामी, सबसे पहले मैं बात करना चाहूंगा सेकुलरिज्म की, जो आपने प्रीएम्बल के, जो हमारा संविधान का प्रीएम्बल है,
धर्मनिरपेक्ष सेक्युलरिज्म।
धर्मनिरपेक्ष का मतलब है कि किसी भी धर्म के पक्ष में नहीं। अगर कुछ लोग इसको धर्म नहीं मानते, पंथ निरपेक्ष भी कहते हैं, तो सेकुलर देश होने का मतलब है कि हम न, हमारे जो देश के जो नागरिक हैं, अधिकांश नागरिक, वो किसी भी धर्म में विश्वास नहीं करते, किसी भी धर्म का पक्ष नहीं लेते, किसी भी धर्म के खिलाफ नहीं है। लेकिन भारत में तो ऐसा है नहीं। अगर हम ये देखें कि दूसरे जो सेकुलर देश जो अपने आप को सेकुलर कहते हैं, इस अभी जो एक पॉपुलेशन का काउंट हुआ है, गिनती हुई है, उसमें 96 कंट्रीज ऐसे हैं जो अपने आप को सेकुलर कहते हैं। बट इन दिस 96 कंट्रीज जो सेकुलरिज्म की प्रैक्टिस है वो बिल्कुल अलग अलग है। भारत में फॉर एग्जांपल हमारे लिए हिंदू कोड बिल भी है, हमारी मुस्लिम्स के लिए अलग मान्यता है, कई तरह के अलग अलग हमारे धर्म को स्वतंत्रता मिली हुई है। यानी कि हम पूरी तरह धर्मनिरपेक्ष नहीं होते भी संविधान में धर्मनिरपेक्ष हैं। तो ये एक तरह का फ्रॉड है, मैं समझता हूं कि जब हम वास्तव में धर्मनिरपेक्ष नहीं हो सकते, अगर हम अपनी तुलना फ्रांस से करें फॉर एग्जांपल, फ्रांस में और भारत के धर्मनिरपेक्षता में बहुत फर्क है। तो हम ये झूठा धर्मनिरपेक्ष का लबादा जो ओढ़ के चल रहे हैं, ये कब तक हम चलते रहेंगे? और उसी प्रकार से दूसरा जो है समाजवाद का है। जब समाजवाद इंदिरा गांधी ने इंट्रोड्यूस किया था, उसके पहले वो देश में गरीबी हटाओ की बात कर चुकी थी। यानी कि जो विषमता की खाई है, उस विषमता की खाई को पाटने की बात थी। इसलिए समाजवाद का मतलब है कि पूरा समाज एक जैसा हो जाए। अब हम दूसरे जो समाजवादी देश हैं उनकी तुलना में भारत की विषमता देखें तो जो देश समाजवाद नहीं भी मानते वो ज्यादा समान है, बल्कि हम जो समाजवाद अपने संविधान में लिखते हैं वो एक तरह से समान नहीं है। विषमता की खाई, आप तो अर्थशास्त्री हैं, और जितने भी विषमता के संकेतक हो सकते हैं, इंडिकेटर्स ऑफ डिस्पैरिटी, indicators of inequality, all those indicators of inequality are more severe in our country, which is called socialist, as compared to the countries which are not socialist or maybe capitalist. So one is this. Second thing is, जो अभी जिक्र आया था कि कम्युनिस्ट पार्टी के नेता विनय विश्वम जो केरल के हैं, उन्होंने सेकुलर और सोशलिस्ट विषय पे जो आपकी जो रिट पिटीशन है इस पे आपत्ति जताई है, और उनका आर्गुमेंट बहुत ही जल्दी आने वाला है। तो ये बहुत ही जल्दी कुछ ना कुछ इस पे सुप्रीम कोर्ट का कमेंट आ ही जाएगा। और मेरा तीसरा प्रश्न जो अगेन डॉक्टर स्वामी और सत्य सबरवाल दोनों मिलकर आंसर करें, बहुत इंपॉर्टेंट मैं समझता हूं कि प्लेसेस ऑफ वर्शिप एक्ट जो है 1991 का, अगर इसको हम स्क्रैप कर दें, और जैसा कि काशी विश्वनाथ की बात है, कृष्ण जन्मभूमि की बात है, तो क्या गारंटी है कि आस्था का प्रश्न किसी चौथे मंदिर के लिए नहीं उठेगा? और डॉक्टर स्वामी, आप जानते हैं हिंदू मानसिकता को, धार एक जिला है मध्य प्रदेश में, वहाँ पे एक भोजशाला है। भोजशाला में ये बहुत अनेक वर्षों से विवाद चला आ रहा है कि वहाँ पे नमाज पढ़ी जाएगी या वहाँ पे सरस्वती जी का जो मंदिर है वहाँ सरस्वती की पूजा होगी। वसंत पंचमी के दिन पूजा को लेकर भी वहाँ पे विवाद होता रहा है और कई बार हिंसक विवाद भी हुआ है। तो ये दो सवाल सोशलिज्म और सेकुलरिज्म के संविधान को लेकर, और तीसरा जो हमारा इसको लेकर, आप दोनों से अपेक्षा है कि कुछ जवाब इसका दें।
Satya, you want to go first or I go first?
Yes,
You'll go first. Go first.
Yes. So अरविंद जी, जो सबसे पहले ये सवाल था कि एक पिटिशनर ने डॉक्टर स्वामी के पिटिशन के अगेंस्ट एक पिटिशन डाली है और उनके क्या तथ्य हो सकते हैं। मैं आज ही उनका आर्ग्यूमेंट आपको बता देता हूँ, उनका आर्ग्यूमेंट क्या है। और उनका आर्ग्यूमेंट ये है कि सेक्युलरिज्म इज पार्ट ऑफ द बेसिक स्ट्रक्चर, और ये एसआर बोमोई के अंदर लिखा गया है कि इट इज पार्ट ऑफ द बेसिक स्ट्रक्चर। लेकिन हम यहाँ पे एक इसको हम डिस्टिंग्विश, मैं इसमें मार्क ये करता हूँ, एसआर बोमोई 7 जज बेंच था, केशवानंद भारती 13 जज बेंच था। जब ऐसा क्लैश होता है 13 जज बेंच को प्रेसिडेंट दिया जाता है। और तो ये उनका एक आर्ग्यूमेंट जहां तक मैं समझ सकता हूं और जितना मैंने मीडिया में पढ़ा है, उनका ये आर्ग्यूमेंट है। दूसरा जो आपका प्लेसेस ऑफ वर्शिप पे था कि अगर हम पूरे एक्ट को हटा दें और उसके कॉन्सिक्वेंस क्या होंगे, कि ऐसा दोबारा तो नहीं होगा या और किसी प्लेस में ऐसा तो नहीं किया जाएगा। ऑलरेडी इस चीज की प्रोटेक्शन हमारे पीनल कोड में ऑलरेडी है। हमारे आईपीसी सेक्शन 295 में अगर कोई भी इंसान वर्बली, फिजिकली या कोई भी किसी भी तरीके से प्लेस ऑफ वर्शिप को डिस्ट्रॉय करता है, उस पर हानि पहुंचाता है, लॉ एंड ऑर्डर सिचुएशन पुलिस के पास है, वो उस चीज में कोर्ट के पास है, पुलिस के पास है, वो एफआईआर दर्ज हो जाएगी और फिर कोर्ट अपनी प्रोसीडिंग्स चलाएगा। सिमिलरली जो 1992 में हुआ, 1992 में जो हुआ 6 दिसंबर को, वहां पे प्लेस ऑफ वर्शिप का कोई जिक्र ही नहीं था एफआईआर में। तो वो तो वैसे ही बहुत डाइल्यूटेड एक्ट है। मैंने आज तक एक एफआईआर नहीं देखी जहां पे लिखा है कि यहाँ पे प्लेस ऑफ वर्शिप की वायलेशन हुई है। एक जो इंसिडेंट हुआ था 92 में, वो वहां पे 295 के बारे में पूरा
लेकिन काशी विश्वनाथ में जो मस्जिद वाला पक्ष है वो प्लेसेस ऑफ वर्शिप का ही नाम ले रहा है।
हाँ जी, सॉरी,
काशी विश्वनाथ का जो मंदिर का विवाद है उसमें जो मुस्लिम का पक्ष है, जो हिंदुओं के मान्यता के खिलाफ है, वो तो यही कह रहे हैं कि इसमें प्लेसेस ऑफ वर्शिप एक्ट आगे आता है। असदुद्दीन ओवैसी कई बार इसको कह चुके हैं।
हाँ, ये जो बात है कि बिल्कुल एक रोड ब्लॉक है प्लेसेस ऑफ वर्शिप का, और प्लेसेस ऑफ वर्शिप में जरूर जब तक ये रिलैक्सेशन कोर्ट के तरफ से नहीं आएगी, या तो एक्सेप्शन नहीं आएगा, या तो एक्ट स्ट्राइक डाउन नहीं होगा, तो वो सूट पे एक बेरिंग तो आएगा ही आएगा। वो उसको स्टॉप करेगा नहीं करेगा। वो कोर्ट ने जस्टिस चंद्रचूड़ ने इसको डिटेल में ऑर्डर भी पास करा था, और वहां पे ट्रायल कोर्ट में जहां तक मेरी जानकारी के हिसाब से है, कल मुस्लिम पक्ष से जो पिटिशन फाइल एप्लीकेशन फाइल हुई थी, ऑर्डर 7 रूल 11 विच इज डिसमिसल ऑफ अ सूट, ये सेक्शन है सीपीसी का, डिसमिसल ऑफ द सूट पे, वो चीज का ऑर्डर शायद कल आना है या तो परसों आएगा उसका ऑर्डर। और अब जो प्लेसेस ऑफ वर्शिप सुप्रीम कोर्ट में चल रहा है, तो जरूर उस चीज पे बेरिंग तो है। सुप्रीम कोर्ट इज सीज ऑफ द मैटर, तो ट्रायल कोर्ट में उस चीज का बेरिंग तो आता है। तो जहां तक मेरा, इसीलिए डॉक्टर स्वामी और हमने जब इस पिटिशन को डाला, हम भी जरूर हाई कोर्ट या ट्रायल कोर्ट जाके सूट को फाइल कर सकते थे, लेकिन हमें पता है कि ये एक रोड ब्लॉक है, इसको रोड ब्लॉक जाना जरूरी है, वरना कोई सूट लाई नहीं करेगा लीगली स्पीकिंग। तो ये चीज हमने इसीलिए प्लेस ऑफ वर्शिप को 2020 के अंदर ही चैलेंज कर दिया था। उस टाइम लिस्ट नहीं हुआ, मे बी कोविड रीजंस थे और उसके बाद अन्य और रीजंस थे। और अब हमने उसको मेंशन करा के नोटिस इशू करने के बाद सबसे पहले हमारी फाइलिंग थी। अगर आप नंबर देखेंगे सबसे पहले हमारी
जी,
फाइलिंग,
बिल्कुल।
लेकिन कोर्ट ने डिफरेंट पिटिशन पहले रजिस्ट्री ने लिस्ट कर दी थी। तो ये चीज है। और तो ये रोड ब्लॉक तो था और इसीलिए हम प्लेस ऑफ वर्शिप पे पहले गए। उससे ओवर टू यू।
हाँ, समय बहुत हो गया तो मैं संक्षिप्त
No,
में
sir. No, sir. There are a lot of people are still waiting, so you can continue as long as you're comfortable.
Okay. I speak in English.
Hindi, please.
हिंदी, ओके। मैं ये कहना चाहता हूँ कि हिंदुस्तान या भारत, जिसको भारत हम संविधान में कहते हैं, वो अभूतपूर्व देश है। माने स्पेन में पहले मुसलमान आया, उसने सारे चर्चेस को तोड़ दी और मस्जिद बनाई। फिर क्रिश्चियन दोबारा जीते तो उन्होंने सारी मस्जिद को तोड़ दी स्पेन में। और ऐसे टर्की में, ऐसे पाकिस्तान में, बांग्लादेश में। परंतु हिंदू देश में जो एकमात्र है हमारी, और नेपाल भी कह सकते हो, हमने आने के बाद जहां भी मस्जिद बनी है उसको तोड़ने के लिए का फैसला किया। यद्यपि विभाजन हुई थी इस आधार पर कि मुसलमान जो नहीं हिंदुस्तान में रहने चाहते हैं उनके लिए अलग देश हिंदुस्तान की ही बंटवारा करके करें। तो मुझे कोई डर नहीं है कि हमारे देश में दंगा करने के लिए लोग बाहर निकलेंगे। इधर उधर दंगा तो दूसरे कारण से भी होते रहते हैं, उसकी बात नहीं मैं कर रहा हूँ। बट इसको एक जिहाद या धर्म युद्ध ऐसी कोई हमारे देश में हो नहीं सकती। मैं आज भी कहता हूँ कि हम लोग बातचीत करें और उन बातचीत से समझाने की कोशिश करें। पेशेंस एक सहन करने की शक्ति होनी चाहिए। आखिर में मैंने जो देखा है कि चंद लीडर्स को छोड़कर, जैसे हमारे हिंदुओं में भी चंद लीडर्स हैं, वो कहते हैं नहीं सब मिटाओ, ये करो वो करो। मैं ये कहता हूँ कि सारे जो हमारे विवादित जगहें हैं उसमें बातचीत होनी चाहिए। सिर्फ इतना है कि जहाँ हम दूसरे जगह अपनी बना नहीं सकते, काशी विश्वनाथ और काशी विश्वनाथ ज्योतिर्लिंग शिवा दोबारा नहीं आने वाला है। किसी को स्वप्न है कि शिवा आएगा और फिर एक और ज्योतिर्लिंग हमारे लिए बना के देगा, ऐसा नहीं होगा। हाँ, एक काशी विश्वनाथ मंदिर है, वो रानी जो आई थी होलकर यानी इंदौर से, उन्होंने कहा कि ये बार बार इस हम बनाते हैं काशी विश्वनाथ की मंदिर और इसको बार बार तोड़ी जाती है, तो मैं अलग से एक बनाऊंगी और उसको तब तक जब तक यहाँ हम मंदिर नहीं बना सकेंगे तब तक यहाँ उस ज्योतिर्लिंग की पूजा हम करेंगे। जो भी ज्योतिर्लिंग वो सच्चा है जो चाहे नकली है उसमें मैं नहीं जा रहा। तो हमारी एडजस्टमेंट तो चलते रहेगी, बात चलते रहेगी, परंतु मैं ये भी कहूँगा कि सबको एक भावना होनी चाहिए कि इस देश में रहना है। सर्वधर्म समभाव एक ही देश में है, वो है हमारी देश में। पारसी आज भी जय जयकार हमारी करते हैं, क्यों? क्योंकि दुनिया भर में गए, मारकाट हुई उनके खुद के देश में ईरान में इतनी मारकाट हुई कि वो ईरान भी मुसलमान बन गया। लेकिन हमारे देश में हमने उनके लिए उनकी मंदिर बना के दी, उनको अपना बनाया। और जब अंग्रेज भी उनको जाते समय कहा कि भाई आपने बहुत सेवा की हमारी सिविल सर्विस में, हम आपके लिए एक रिजर्वेशन देंगे, उन्होंने कहा नहीं, हमारा 1000 साल के लिए हिंदुओं ने हमारी देखभाल की, हमें तुम्हारी जरूरत नहीं है, तुम जाओ। यहूदी भी ऐसे ही, यहाँ सब जगह में यहूदियों की मारकाट हुई है। इजराइल बनने के बाद पहला अधिवेशन में उनकी पार्लियामेंट में उन्होंने कहा कि धन्य हो भारत, एकमात्र देश दुनिया में जहां यहूदियों के साथ शोषण नहीं हुआ। तो ये परंपरा में हमारे हैं, और आज भी मैं कहता हूं कि हाँ, ये 3 के बारे एक तो हो गया है, अब उसमें भी थोड़ा जल्दबाजी हो गई और यानी वो तोड़ दिया, ये कर दिया, वो ठीक है, बट मैं कहता हूँ ये 3 में एक अर्जेंसी है। ये 3 होने के बाद फिर बाकी सब नेगोशिएशन में ही चलेगी, क्योंकि उसमें सिर्फ मूर्ति की रक्षा है, इसीलिए एक मंदिर बनेगी, बगल में बन सकती है, सब हो सकता है। तो इसीलिए इस रास्ते से हम आगे बढ़ेंगे तो मुझे नहीं लगता कि इस देश एक उदाहरण हो जाएगा दुनिया के लिए।
Okay, thank you, Dr. Arvind.
Just saying, Dr. Swami, on behalf of all the viewers, they're all wishing you advanced birthday wishes. And on behalf of even on me, I'm saying advanced birthday wishes.
Okay.
Go
Thank you.
Arvind ji.
Yeah, thank you, Dr. Swami. These two topics are very important topic currently, and everybody's. That's why the enthusiasm that was seen in terms of it manifested in terms of the comments which we were making. And in fact, when you mentioned that the time is short, some of the viewers even said, "No, we have sufficient time. Please go on. Don't stop the program." So that shows
we'll have more sessions on as the court proceedings proceed to give you
That's right.
updates.
So in coming days, when Supreme Court also starts hearing on these two issues, which people really have very much interest in, and naturally the public interest will also go up. Satya, thank you very much for helping Dr. Swami in drafting this program. In fact, Dr. Swami and Modi, there is this contrast. Contrast is Dr. Swami does not want to take the credit even for the work he does. And in the beginning, he only said it is all due to Satya Sabharwal that he has done the drafting. And I mean, of course, there's no point in saying the contrast that I'm talking about. I mean, there are people who want to take credit for things which they have not done, they've not moved even an inch. But anyway, that apart. Thank you, Dr. Swami, for bringing this important issue. Because when we are talking about Krishna Janmabhoomi, or when we are talking about Kashi Vishwanath, both of them are under litigation currently, and a lot of public interest is being generated. And these two are linked with Places of Worship Act. पूजा स्थल विधेयक 1991 जो हमारे संविधान का एक जैसे सत्या सबरवाल का एक ब्लॉक है, तो वो इन दोनों के निर्माण में और अंतिम निर्णय में बाधा है. So it is very important for you to take it up with the concerned court. And there are many issues. Preamble, maybe there is one MP who is opposing you, but there are many supporters among the general public who think the secularism has not delivered. Socialism has not contributed to anything. In fact, I was looking at the list of the countries which call themselves socialist, and if an empirical study is done to find out whether socialism has anything to do with development, socialism has anything to do with growth, socialism has anything to do with the, let's say, increase in per capita income, nothing. And this can very easily be proved that the word socialism, by being put in the preamble of the Constitution or calling ourselves socialists, we are not going to add anything. So it is not really a crown sort of which should be used. Thank you, Jagdish Shetty ji. Thank you, Ramesh Swami. Thanks the technical team led by Ashish Shetty, Gadgi Rakesh, Ishwar Iyer, Tejas Swaminathan, Vishal Mehta, Najesh Nair, without whose efforts this success of this program cannot be ensured. They are really doing, and the public support, program by program, Sunday after Sunday, is really increasing. Though Jagdish did not quote the figures for last Sunday, but I'm sure this must have crossed 1.5 lakhs, which is now become some sort of a norm, a minimum for viewership after a week. Thank you, Dr. Swami. We'll be meeting again next Sunday after your breakfast, after your birthday. We are celebrating in a very small way. We are celebrating, not for the public function, but Virat Hindustan Sangam will celebrate Dr. Swami's 84th birthday on 15th September in Delhi. And 18th September, we'll also be talking about Dr. Swami's contribution to the social and economic life of the country, especially the parliamentary system. Thank you, Dr. Swami. Thank you. Next Sunday, 18th of September, we'll meet again at 8 o'clock. Till then, Namaskar. Jai Hind.